This is Lindsey Claire Muse in Business Law. Today I'll be talking about contracts. A contract is a legal binding agreement based on the genuine assent of the parties, made for a lawful object between experienced parties in the form required by law and generally supported by consideration. In other words, a contract means that both parties are legally bound to do or to refrain from doing certain acts. Contracts can be about goods, properties, or services. The parties in a contract may include individuals, partnerships, corporations, or governments. There are 6 elements that make up a contract. First is an agreement. A contract is based on an agreement. An agreement arises when one person, the offerer, makes an offer and the person to whom the offer is made, the offeree, accepts the offer. Second is that it has to be between competent parties, which means both have to have legal capacity to enter into a binding agreement. Third is that a contract has to be based on the genuine assent of the parties. Fourth, it is must supported by consideration. Consideration is a promise or performance that the promisor demands as the price of the promise. The person who makes a promise is the promisor, and the person to whom the promise is made is the promisee. Fifth, the contract is made for a lawful objective. And lastly, the contract must be in form required by law. I will now discuss the different classes of contracts. First is formal and informal. Formal contracts are either contracts under seal in which a person's signature or a corporation's name is followed by a scroll or the word seal. Contracts of record that are obligations that have been entered before a court, or they are negotiable instruments. Informal contracts are simple oral or written contracts. Second are expressed and implied contracts. Expressed contracts are an agreement of the parties manifested by their words, whether spoken or written. An implied contract is expressed by conduct or implied or deduced from the facts. An implied contract cannot arise when there is an existing express contract on the same subject matter. Third are valid and voidable contracts and void agreements. Valid contracts are agreements that are binding and enforceable. Voidable contracts are binding and enforceable, but because of the circumstances surrounding its execution or the lack of capacity of one of the parties, it may be rejected at the option of one of the parties. Void agreements cannot be enforced and have no legal effect. Fourth are executed and executory contracts. An executed contract is one that has been completely performed. Executory contracts are the opposite, in that something remains to be done by one or both of the parties. This may have to do with payments or deliveries. Fifth are bilateral and lateral contracts. Bilateral contracts is when a promise is given in exchange for another. Unilateral contracts is one when a party promises to perform after the other party does not designate an act. When bilateral contracts look ahead to the making of a later contract, it is called option contracts or first refusal contracts. In an option contract, one party has the right to enter into a contract at a later date. A right of refusal only gives the right to make an offer. Last, we have quasi-contracts. In this type of contract, the court imposes obligation to prevent unjust enrichment in the absence of a contract. A quasi-contract is not a true contract reflecting all the elements that I have stated earlier. To have a claim of unjust enrichment, 3 things must occur. First, a benefit must be conferred on the defendant. Second, the defendant must have knowledge of the benefit. And third, it must be found that it is unjust to retain benefit without payment. In a quasi-contract, sometimes it may be unenforceable because of a failure to set forth the contract in writing in compliance with the statute of frauds. Sometimes one party may have performed services for the benefit of the other party, and the court will be required payment of the reasonable value of services to avoid the unjust enrichment of the party receiving the services without paying for them. This is called quantum merit, which means as much as is deserved. In a quasi-contract, when a plaintiff recovers the reasonable value of the benefit conferred upon the defendant or fair value of the work performed, it is called extent of recovery. So, in summary, a contract is something more than just an oral promise. It must contain the 6 elements that I stated earlier, and from there it is put in one of the 12 classes of contracts. Thank you.